You certainly knew that there were eyewitnesses to the condition and the location of Miss Reed's SUV, correct? Are you aware that the longest delay of any report in this investigation was 581 days?
He reminds me so much of cop in the OJ trial. Forman, Mark Forman, reeks of Forman.
It is important to interview anyone that's an eyewitness. Sometimes it takes longer because... Are you listening? I'm sorry.
Thanks.
You asked the question, I just wanted to answer.
Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, today we're going to continue with the testimony of Yuriy Bukhenik. I know right now in court we have Brian Higgins, and I cannot wait to start breaking up his testimony and feeding it to you all on a silver platter. And this evening, we're also going to be doing another surprise witness. Which one is it going to be? Only one way to find out. Tune in at 7 p.m. Eastern tonight, or 4 p.m. Pacific if you're on that coast. Europe, I don't even know what time it's going to be your time. Just add like 6 or 7 hours. So, without further ado, I bring you the continuation of the cross-examination by Alan Jackson, trial number 2, Massachusetts versus Karen Reed of Yuriy Bukhenik. Let's go.
If you'll take a look at those 4 documents, do those appear to be the veterinary records that you gathered related to this animal?
I wonder if he doesn't recognize them, he doesn't remember, he's trying to make sure it's all there.
Yes, it does.
Do any of those records, any of the veterinary records, the 4 pages that you're holding, even include the name Cora or the name of the new owner?
Oh, that's a good question.
I browsed through it, and no, it does not appear that Cora or the new owner are included in any of these 4 pages.
May I approach?
Yes.
You don't have any transfer records for Chloe, correct?
No.
All the records that are provided by the owner.
I'm going to go through a series of questions, Sergeant. If you can answer it yes or no, that might make it go a little faster. You don't have any transfer records, correct?
I would know what it looks like. That's
Oh my
why
God.
it's even quicker me telling you that that's all the records that I have.
Yes or no?
I want an answer to my question. You
Okay.
don't have any transfer records.
I don't know what a transfer record would look like, so
the
I
answer
can't.
is no.
I don't know.
Okay. You don't have any rehoming records.
No.
I don't know.
You don't have any purchase records.
No.
I don't know.
What do you mean you don't know? You either have them or you don't. The Greeks used to say, estin euk estin, like 3,000 years ago. Either a thing is or it is not. Like it's either in existence or it's not in existence. How can you say I don't know? The question is not, do these records exist in the universe? That's not the question. That would be a legitimate answer. Do these records exist in the universe? I don't know. That would be a legitimate answer. Do you have these records? Yes or no? The answer is no. You can't, what is it, Schrodinger's records? They both exist and don't exist at the same time? Come on, dude. Estin euk estin. Do you have it or do you not have it? I don't know. Makes him look like a fool. I love it, but come on, man. Just say no. It's not gonna like destroy the case. By the way, for those of you who may be following the case very closely, in May 2025, as this is unfolding, because I'm recording this in the morning of May 14th, the day it's going to premiere. So this is very, very fresh. This is about as fresh as it comes. Folks, Ronnie, juror from trial number 1, appeared on the news again. Did you guys see that? Oh, yes. Ronnie appeared on that, Good Day Live show or whatever they have in Massachusetts over there in Boston. And he said, they asked him about the dog. They're like, what significance or what relevance did the dog play in your determination of the case? And he, again, remember, he's one of 12, so his opinion is not the word of law. It's not he doesn't speak for all the other jurors. He only can speak for himself. But Ronnie all but said, like, dog schmog, I don't care. The dog's relevance is completely insignificant in my determination of the facts of the case. I had a conversation with my girlfriend Chandler last night, And she pointed out something very, very scary and very, very true about this case. And I want to share it with you all because it's very, very poignant. And love you, baby. Here's the thing about the Karen Reed trial. 99% of the world, rightfully so, is 100% convinced that Karen Reed is factually innocent. However, these scumbags who have pinned a crime on her and have created this elaborate conspiracy where they're all protecting each other, it's the Irish way. It's the Irish way. Nobody rolls on anybody else. We protect one another till death do us part. They are protecting one another in a fashion that is unprecedented, something you have never seen before. I have never seen before. It's like Whitey Bulger all over again. John Dillinger, you know, like name a gangster, a famous gangster, not Bonnie and Clyde. They were kind of entrepreneurs, if you will. But you understand what I'm trying to say, I think. And these people have created this elaborate conspiracy, and it's Occam's razor, right? The simplest solution to the quickest path is usually the correct one. The simplest answer is usually the correct one. And to try and like say John went in the house and all that, yes, we know that happened, but the defense has to at least disprove that he was hit by a car, and that's a very, very high task, Chandler said. And I was like, what are you talking about? And then she started breaking it down for me a little bit. And again, Occam's razor over and over just kept ringing in my head, and I went, holy crap, she has a point. And it really scared me for Karen because we all want her to be acquitted. Everybody in the world wants her to be acquitted except the 0.1% of bootlickers who think she is absolutely guilty. Because again, Occam's razor, those people who are like, what are you talking about, Larry? Larry, you must be drinking again. Forget those 77 months sober you talked about the other day. You must be hitting the bottle because how else would you come to the conclusion that she's innocent? I'm like, have you been watching the trial? No. I just heard she hit him with a car. End of story. And that, my friends, right there is Occam's razor at work, in play, in the real world. The whole idea that Karen Reed is factually innocent and evidentially innocent. In the outside world, Chandler pointed out that there are two trials going on at the same time. The first is the trial by public opinion, which kind of like in the Johnny Depp versus Amber Heard days, if you remember, there was the trial of Amber in the court of public opinion, and there was the trial of Amber in the court of law. Same thing is happening here. In the trial court of public opinion, Karen has already won. If we could vote right now, 98 to 99.9% of the people will vote not guilty, and 0.1% all the way up to maximum of 2% of the populace will vote guilty, and she would walk away. And she has already won, like I said. But in the court of law, because Auntie Bev is in cahoots with the Alberts and Canton PD, etc., as a result of that alliance, they have formed an almost impenetrable wall. They only had 2 slip-ups in the last trial. Nicholas Barrows said the taillight was only cracked and not broken, which I don't even know if the jury noticed. And Ally McCabe said John went in the house. John wasn't in the house, or sorry, Colin wasn't in the house when John was there. I've populated this short if you haven't seen it. It's very on point because her mom and dad say John never went in the house. It's not a story. You know, they're synchronized word for word. Word for word. They synchronized their story. The McCabes did. But Ally McCabe accidentally went off script. Let me show you the clip so you understand what I mean.
John never went in the house. It wasn't a story. It was the truth.
Matthew and Jennifer have been practicing a script for many, many months. But then their daughter accidentally goes off script and says the complete opposite.
Colin wasn't at the house, so he was not at the house when John was there, so I drove him home.
Colin was not at the house when John was there. Oops. You see what I mean? Ally McCabe goes off script. And she accidentally puts John in the house. Now, since then, they have decided they're not going to call Nicholas Barrows. They're not going to call Ally McCabe. I'm sure Ally McCabe has been doing push-ups mentally in training, and I'm sure she got the snot beat out of her by her mother and her father for almost tanking the entire trial single-handedly. And now they've plugged up the holes. They've got their stories even more ironclad. Yes, there's a bunch of like new inconsistencies, but they're trying so hard, and they're all working in cahoots with one another. They're a corrupt system, and exposing an entire system of corruption is not easy. It's not an easy task. It's a very tall glass of water to fill. And as a result of that, Chandler is convinced that we're gonna get a hung jury again, and all she all but said it. I don't think she thinks that. I think that. I've already talked about it. I tweeted about it. If you haven't heard me say it, you heard me say it now. There is no way, absolutely no way, that we're going to have a conviction, and there is almost no way that we're going to have a full acquittal. I don't see it. I can't see it happening, unfortunately. I keep coming back to this. You know, there was this one case in Indiana. His last name starts with a C. It's like Comey, police officer. He was prosecuted 4 times. 4 times he went to trial. Hung jury, hung jury, hung jury, hung jury before the prosecution. I think the prosecution was going to go for a 5th, and the Supreme Court said, stop it. You're done. Leave the man alone. They've been prosecuting him for like 12 years or something crazy like that. I'm not exaggerating. It's an insane case, very famous. I just can't remember his name right now. And you can look it up. And let me know in the comments below if you find it. As you're scrolling down, don't forget to subscribe. So the problem is there is so much conspiracy, and they got their stories ironclad, and that's the most unfortunate part. We're waiting for a slip up, and it might happen, and I hope it does. And even if it does, I don't know if the jury is quick enough or smart enough to pick up on it, because these nuances are only important if you know the full story. They don't know the full story. They only know what's being fed to them. That's by design, because you want a neutral, unbiased jury. That's 100%. I agree with that. You want a jury that's not familiar with the case, because if they're going to be familiar with the case, they're already coming in with a preconceived notion of guilt or innocence, and we don't want that in our justice system. Would you want that for your jury? I mean, sure, if it's they believe you're factually innocent. What if they believe you're factually guilty before the trial even starts? Would you want that person on your jury? Of course not. So now the problem becomes, what do you do? How do you get away from this? And the one thing that really, really struck me is we went back to the first trial, Chandler and I. We had a full conversation last night on May 13th, 2025. And today's May 14th, like I said, 2025. For those of you watching in the future, hello, hope you're enjoying this. But for those of you watching today, I mean, this is fresh, like I said. And so the question becomes, why did they acquitted on murder 2. They were split 8-4 in favor of conviction on negligent homicide while operating a motor vehicle under the influence. But then they were not guilty. And this is what really struck me, like thinking about Chandler's theory. If she is correct, and the jury is just going to go with the simplest solution, makes the most sense, that the jury is just going to go, well, she did it, you know. She has a point. You know, jurors are people. You know, when I did the cross-examination of Paul Gallagher, I was having so much fun, and then I watched myself, you know, doing it, and I realized it's so specific because I'm a specialist. It's a specialty of mine, so of course I'm going to enjoy it. But to the outside viewer, it's very confusing. It's very technical. I very much want an acquittal. So the trial of public opinion, of course, she's acquitted 2 years ago. But in the court of law, they're doing everything in their power, and it's scary to think about that they're doing everything to try and convict her. And I still don't think it's going to work. But explain to me why in trial number 1, chat in the comments below as you scroll down and you subscribe and hit that notification bell so you don't miss the next video. Why is it that they were 8-4 split on negligent homicide while under the influence of alcohol? What happened after that? She left and went home. The next charge number 3, leaving the scene of an accident. Why were they going to acquit on 3? Were they just going to split the baby? Like, I don't understand. If some of them, 8 out of 12, let's say, agreed, yes, she did this. If she did it, why not also convict on charge number 3? Why weren't they split 8-4 on charge 3, leaving the scene of an accident? You know, you begin to wonder. And of course, you can't look past the jury plant. The police officer who Bev made the foreperson in trial number 1 they knew who he was, and they wanted to make sure that he's the one who's going to get the elevation, right? You are now a super juror. You are appointed by the court. See, this is so weird. South Carolina, I understand, does it. I think I remember from the Murdaugh trial. This case, they do it in Massachusetts. Kentucky's not like that. Kentucky's instructions say you are going to go back and you are going to pick a foreperson. I don't like it when a judge intervenes and injects itself in saying, you are the foreperson, Mr. or Ms. So-and-so. Because now they feel, I have the power. I've got the power. Like, why? Why? And how much influence, this was my question to Chandler, and she doesn't really have an answer for it, and I understand why. because it's too speculative. If we are to assume that the juror that was elevated by Auntie Bev, that juror was in essence the best pick for them and elevated, and he was the one leading the discussion. Maybe he's the one who was able to bring 7 people with him on charge 2, but then decided to throw charge 3 under the bus. That's my only explanation, because otherwise, let me know in the comments below, what's your theory? How is it possible that they, like, let's assume 8 people on that jury who voted guilty on charge 2, negligent homicide while under the influence of alcohol, right? So Karen shows up. This is John. Charge 2 and 3 are brother and sister. They're not even cousins. They're brother and sister. Negligent homicide while under the influence of alcohol and then leaving the scene. It's A, B, and C. Why did the jury, 8 of them, wanted to convict on charge 2, which is parts A and B, hitting him and being under the influence, and then they're like, well, but she never left the scene. Do you understand how illogical and stupid that sounds? Something was amiss in those juror discussions, and I would love to know what it was. And I think we will never know unless a juror comes forward, let's say if trial number 2 ends in a full acquittal, which I'm praying for. I want Karen, don't get me wrong. I mean, I've said all of this, and I will just end it on this before we get back to Bukhenik. 3 charges. I want an acquittal on all 3. Not guilty, not guilty, not guilty. Jackson's opening. He is priming the jury because he doesn't want the exact same thing to happen in this trial that happened in the first trial. Now, we will find out if it worked in a few weeks here. I believe the trial is probably going to go to the end of June, easily. We're now in the middle of May 2025, for those of you watching as this is unfolding. And I don't know, folks. I don't know. I am hoping for the best, but I'm also preparing for the worst. And if we get another hung jury, each time it's going to become increasingly more difficult for the prosecution to prosecute Karen, because there are just too many lies to juggle. Too many new facts, old facts, fabricated facts, made up facts. So again, I say this tongue in cheek, but you know, trial number 3 for Karen Read may not be the worst thing. I mean, financially, hell yes. It's like, come on. She's already, I read somewhere she's $5 million in debt, paying all her lawyers. I mean, she's got 4 lawyers now, and they're working round the clock, both during jury trial days and non-jury trial days, for 2 years now. You know, this is going into full year 2. So going into year 3 is going to kill her even more. And God bless, she's got some help from her friends at Fidelity, I understand. She was a banker. She worked in finance. Not banker, she worked in finance. Yeah, I mean, I don't want trial 3 to happen, but I keep saying that's my prediction. I think that's where we're headed, folks. I think Canton PD and the Commonwealth and the judge have all created this atmosphere that is essentially all but mandating a hung jury, a mistrial. Unless they get a conviction, like across the board, or let's say they do unite somehow, like they couldn't unite in the first trial, like not guilty 1, not guilty charge 3, but guilty charge 2, or something stupid that doesn't make any sense. And Karen's gonna appeal, of course. I don't get it, folks. I don't understand, like, what is happening in the jurors' minds, because now, forget all the corruption. Chandler said the right thing. Stop thinking like a lawyer, Larry, and start thinking like a juror. And that's very difficult for a lawyer to do, because they used to joke around that when you're done with law school, you're no longer a reasonable person. For those of you who are not familiar, the reasonable person standard is a standard to basically determine whether or not negligence has been committed. That's like the easiest way to think about it. And because we know the law, we're no longer reasonable people. It sounds stupid to say, but it's absolutely true. And by the time Chandler is going to graduate from law school in May of 2028, she is also not going to be a reasonable person anymore. But right now she is. And she pointed out, and she was like, Larry, think like a juror. And I paused, and it was really, really hard. And I fought, and I was like, wait a minute, you can't say that. And I'm mad at you, and da-da-da, how could you, like, house divided? No. I stopped myself, and I was like, hold on a second. She has a point. Think like a juror. Try that, folks. Try it for yourselves. As a juror, it's very difficult to do, even for you all, and you're not lawyers, those of you who are not lawyers. Try and distance yourself from the facts and just watch it as if you're watching it for the first time, and you have to determine guilt or innocence. The theory, even with the new theory, John was never hit by a car, is still a very tall glass to fill. And I hope it gets filled. At the end of the day, if we get an acquittal, I think the FBI can swoop in and start arresting people. I think that's what they're waiting for. I'm convinced the FBI is still chilling, if you will. But if we get a conviction, they may or may not come in. That's what Canton is hoping for, the Albert Mafia and their lackeys. And then, of course, the most important, if there's an acquittal, or excuse me, if there is a hung jury, we're going to go into trial number 3. And once again, I reiterate that there are going to be a couple jurors on there that are going to be very, very smart, very intelligent. That's why the split was 8-4 on negligent homicide while operating a motor vehicle under the influence. 8 people were like, well, she was drunk. She said I hit him. Guilty. That is terrifying. That is the most terrifying sentence I have ever said in my entire life about this case. And I hope it doesn't come to pass. So I know I've been on my soapbox for a little bit, but I wanted to share my thoughts with you all because that's what you're here for. You come for the analysis. You come for my legal mind. So let's get back to the video.
Are those 4 pages of veterinary records that don't have the name Cora and don't have the new owner's name, correct?
That's correct.
You would agree, shifting gears for a second, that timely report writing obviously is an important aspect of any investigation, correct?
It is important, but we can only write reports as feasibly and possibly we're capable of doing. Sometimes investigations are rapid, so you can't write a report. You take notes, and some time goes by before you actually document the information on an official report. The information's there, it's gathered, it's maintained by the investigator, it's shared, it's acted on at times, but the official reports might take some time to write.
So obviously, if you're, like you said, things are fast moving in an investigation, it might be that you interview a witness on a Tuesday, you're super busy on Tuesday, Wednesday, Thursday, it might be Friday before you can even sit down and draft a report about that interview that you did on Tuesday, correct?
Different circumstances dictate differently.
That would be completely normal.
Yes, it is.
But most
Also, you know what I want to know? I want to know what is Yuri on because he is so slow to respond. Unless it's intentional. It's like he popped some Xanax before he took the stand just to kind of like slow his nervous system down. What do you guys think, chat? Let me know in the comments below. And by the way, if you need a lawyer, 1-844-774-HURT. 1-844-774-HURT. If you're hurt in an accident, truck, UPS truck, semi, car, motorcycle, bicycle, pedestrian, it doesn't matter. Dog bite, slip and fall somewhere, and you're hurt and you need a good trial lawyer to get you the most money for you, call us. We just settled one case, $750,000, very recently. Car versus UPS truck. Good policy, $1 million policy. Client got $750,000. It's very, very simple. You just got to do things right, and you got to make sure that insurance companies respect you as a lawyer, because otherwise you're not going to get anything, or you're going to get very little.
of the time, it's best practices, and you're taught, and you teach your subordinates that it's best practices to reduce to writing and memorialize a report as close in time to the event in question that's being memorialized as you can, right? Perfect world.
In the perfect world, we'd write it as it's happening. Where? No.
Are you aware that there are 4 reports that are more than 500 days from the time of the event that's being memorialized?
I am not aware, no.
Are you aware that the longest delay of any report in this investigation was 581 days?
I am not aware of that, no.
Wow.
You became aware early on in your investigation of 2 individuals named Ricky D'Antano and Heather Maxson, correct?
They are witnesses, yes.
Now, Heather already testified. Ricky has not testified yet, as far as I know. Correct me if I'm wrong in the comments below. And as you scroll down, don't forget to subscribe, hit that notification bell so you don't miss the next video.
Both Ricky D'Antano and Heather Maxson, you learned, were outside 34 Fairview in the early morning hours of January 29th, correct?
We did learn within our investigation at some point, yes.
And you learned, Sergeant, very early on in that investigation because you interviewed Ryan Nagel in February of 2022, which is just days after the event, correct?
I'm not sure of the exact date.
Obviously, as you just said, you became aware that Ricky D'Antano and Heather Maxson were witnesses in your homicide investigation, important witnesses, you'd agree, correct?
They were witnesses.
You learned that they arrived at the house at 34 Fairview sometime after Karen Reed and John O'Keefe arrived and pulled up behind their parked SUV, correct?
Objection.
I'm going to allow that.
That's a good question. Yeah.
Can you
why-
repeat that, please?
Sure, you learned that where they fit into the investigative puzzle is that they pulled up behind Karen Reed's SUV when Karen Reed and John O'Keefe arrived at 34 Fairview. They pulled up sometime after that and pulled up right behind them, correct?
That's not correct.
What is not correct about that?
They arrived simultaneously. Karen Reed took a right onto Fairview. They yielded to them and followed towards 34 Fairview, stopping at the driveway as Karen Reed proceeded further up.
Did you listen to the testimony in this case up to this point?
No.
There's a sequestration order, correct?
Oh.
Yes, yes.
Which means you can't listen to the testimony of witnesses, eyewitnesses who are testifying in front of these jurors. Is that
Correct, yes.
You don't know how witnesses have testified from that witness box in front of these jurors, correct?
I have no idea.
Okay.
Liar.
So your information is that they pulled up simultaneously, correct?
It's-
Is that what you just testified?
That's my memory from what the the interview produced.
I swear, he reminds me so much of, oh God, what was the name of the cop in the OJ trial? Forman, Mark Forman. He like reeks of Forman.
You certainly knew that there were eyewitnesses to the condition and the location of Miss Reed's SUV, correct?
Yes, yes, from their interviews, yes.
And you also are aware that they would have been in a position to see the occupants of Miss Reed's SUV as they were behind it and then pulled around it, correct?
Objection.
Sustained.
Did you become aware that they were in a position behind the SUV and as they pull around it, they could still see the SUV?
Objection.
Sustained.
You knew what potential role they played in your investigation as eyewitnesses, correct? Generally?
When we interviewed them, when we learned of their existence, when we interviewed them, we collected information based on their recollection.
Okay. My question was, you're aware that they had a certain perspective as it relates to the SUV that night, the early morning hours, right?
Based on their interviews, they had a perspective with the brake light being on constantly.
I'm not asking you what they said.
He has been
I'm
watching
asking you,
testimony.
During the course of your investigation,
I'm
you learned
convinced.
that Ricky D'Antonio and Heather Maxson had a perspective. They were eyewitnesses to certain things. As
Yes.
relative to the SUV, correct?
Yes.
And Ryan Nagel too. But that was a different car. Sarah Levinson was
You
in
instructed
one
your
of them.
subordinate, Michael Proctor, to interview those witnesses in August of 2022, correct?
I'm not sure when they were interviewed. I don't have a memory of instructing him to go interview them.
Wait, that's interesting. Jackson just called former disgraced Massachusetts State Police Trooper Michael Proctor Bukhenik's subordinate. I don't remember that being like a fact in the first trial unless I'm missing something, but it smells like Jackson just decided to kick Proctor down a notch, and I wonder why. Maybe because it's a fact, or maybe it helps Jackson. I don't know. It's interesting.
May I approach, Your Honor?
Yes.
Thank you, Sergeant. Does that refresh your recollection as to a conversation, or I'm sorry, a communication that you had with Michael Proctor?
Unfortunately, it does not. I will take the document at face value. I do not have a memory of having these communications, but I will take the document if it's authentic and it is true and accurate that it took place. But I do not have a memory of sending these text messages.
Yes.
Interesting turn of phrase. I don't have an independent memory, but
Also, my name's misspelled in there. Is that from the extraction, or where is that from?
Couldn't tell you. Wasn't me.
Appreciate it. Thank you.
I can't take credit for that.
Bukhenik is hard to spell.
If your memory is not refreshed about that particular communication, do you remember in general communicating with Michael Proctor about interviewing Ricky D'Antonio and Heather Maxson?
I do not know. I'm sorry.
Would that have been something that you would have found important relatively early on in the investigation? These are eyewitnesses. Let's get them interviewed.
Yes, it is. It is important to interview anyone that's an eyewitness. Sometimes it takes longer because. Are you listening? I'm sorry.
Thanks.
You asked the question. I just wanted to answer.
I know the answer to my question.
Okay.
Okay. So while we want to interview every eyewitness, sometimes an important fact is already detailed and witnessed by another witness. So in this situation, we had already interviewed one of the occupants, the one that was driving, the one that had the observed the events taking place, and we asked him if we were going to talk to the other two, would they have the same recollection, observations? Did they leave the vehicle to go in the house at all? Anything like that? Anything different? So that's...
Okay, so it would be important, obviously, to interview.
It would be important to interview witnesses. So that's all for that clip. We're gonna revisit Bukhenik again. This is not the end of him, especially I think he read Proctor's texts, I understand, and he has been testifying a lot as if he is Proctor. And right now, of course, we have Higgins on the stand. As I'm recording this, Higgins is about to take the witness stand once again as the trial resumes, since we had no trial yesterday. That's why I released long form videos at 1 o'clock and 4 o'clock, where normally I do a short at 1, and then this is all Eastern time, by the way. I normally do a short at 1 and then 2 videos at 4 and 7, but yesterday I did long form video at 1 and 4 because there was no trial, and I wanted to make sure that you guys got some content. Today, this is probably premiering at 4 p.m. Eastern Daylight Time. I already had a short at 1 o'clock this morning, this afternoon, and we'll have one more video in 3 hours tonight at 7 p.m. As we're still playing catch up, I will continue cranking out 3 videos a day, which is the maximum YouTube allows notifications for. So I appreciate you all. Let me know in the comments below, and don't forget to subscribe about what you think about Chandler's proposition that jurors are simple people. Occam's razor, the quickest way wins. You know, the easiest path to the most obvious answer is going to win the day. And jurors are people, and people, for the most part, they want a simple answer to a simple question. Did she kill him? Sure, why not? Whatever. Can we just move on? Versus, did she kill him? No, it was actually a conspiracy by a bunch of people and da-da-da. Again, I'm not, by any stretch of the imagination, you know, I'm sure the haters are going to go, Larry changed his tune. No, I did not. I had absolutely no change of course, no change of tune. As they like to say, I'm going to continue on grifting off of this. So now being an independent reporter and an attorney is grifting. So I guess when you watch MSNBC or Fox, CNN, or whatever, they're all grifters too, and that's fine. I don't care. I'll join that fray. But essentially, being an independent reporter in 2025, unless you say what they want you to say, you are automatically labeled a grifter. So whatever, don't care. Their opinion matters not to me. However, I will say that I'm sure that they're going to have a field day, because it smells like, you know, in this video, I'm talking about very, very difficult things, very painful things to hear for us in the Free Karen Reed camp. So it's okay to break things down and analyze them and to think about them. You know, of course, I'm not switching sides or anything stupid like that. That's ridiculous. It's just my eyes are open to the fact of reality. Because reality, you can't dodge reality. You have to be mindful of reality. And the reality is jurors, well, okay, let me rephrase that. The reality is most people are stupid. Can we just agree on that? For if nothing else, I want to leave you with this. Most people are dumb, okay? Not you guys. You guys are awesome and smart because you're my audience. But let's just say when you go outside, you got to watch out for people. Because there are schmucks around and just like, I can't trust, this guy's gonna run me over, this guy's drunk, this guy's got a gun. Like, the world is a very, very dangerous place. And most people are stupid. And that's okay. And you would know this, and I know this. So you have to assume there are gonna be several people from this stupid realm who are probably sitting on the jury going, I don't understand what's happening here. I think she hit him. And they're not gonna hear anything else. So that's the reality. And we have to drink a lot of copium to try and kind of get over it, and maybe there's an answer somewhere. But I'm still convinced that something is going to happen. I can feel it in my gut. There is an imminent strike, like a nuclear strike, that is going to happen in this trial that has not happened in the first trial. I don't know who's cooking it. I don't know if the defense is cooking it. I don't know if the prosecution is going to slip up. I don't know if a prosecution witness is going to slip up. I don't know if a defense witness is going to blow up the entire courtroom like Lucky did that one time. What a great name, by the way, nickname, Lucky. He was in the right place at the right time to find the right thing for the right case. It's unbelievable. It's just, you can't make this stuff up. His nickname is Lucky for a reason. Anyway, I'll stop boring you with my rants. I think I've shared everything I wanted to share with you all on this topic today. So I will see you all in the next video, and I hope you enjoyed it. Bye, everybody.